Were you selected in the H-1B lottery that was conducted last week, or were your employees? Today, we're talking about some of the top frequently asked questions for submitting H-1B Cap petitions after the H-1B lottery. My name is Emily Sumner with Sumner Immigration Law, and I'm so glad that you are joining us today for Live at Lunch, whether you are joining us live or catching the replay. If you have questions about this particular topic, about FAQs for H-1B Cap filings, or any other question relating to employment-based or family-based immigration matters, please put those in the comments and I will address them as I can. As always, this information is for informational and educational purposes only and is not legal advice. So let's get started. The H-1B lottery was conducted the end of last week, all through the weekend, and we notified our clients who were selected in the H-1B lottery, the employers who were selected in the H-1B lottery starting on Friday and through the weekend. So congratulations to everyone who was selected in the lottery. One note, if you were not selected in the H-1B lottery, we are having a free webinar tomorrow, April 2nd at noon Eastern. I will put the link to register for that webinar. It's about options beyond the H-1B because, believe it or not, despite all of this chatter about the H-1B visa classification, and it is a widely used one and well known, there are options beyond the H-1B. So if you are not selected in the H-1B lottery, I hope that you will join us for that free webinar tomorrow. If you register, we will send you a link to the recording of that webinar, even if you can't make it live, though I hope you can make it live because I like to answer people's questions and make it interactive. So again, if you have questions as we are going through these FAQs, put them in the comments and I will answer them as I can. So the first question is, when can we file the H-1B Cap petition? The answer is starting April 1st, which happens to be today, through June 30th. One tip, you want to file the H-1B petition as soon as you can. In general, you don't want to rush it. You don't want to submit, a sloppy petition for sure, but you do not want to wait until June 20th to start thinking about this. The reason is a couple of things. First, it takes time to put everything together. I'm not saying that this is going to take an extraordinary amount of time from the HR team or from the employee or really anyone, but it does take time for us to gather the information, to come up with a full and complete strategy for the filing of the case, to get the labor certification, labor condition application, LCA, certified, and you don't want to wait until the last minute and then potentially there's some tiny error in the case and the case is rejected. So it has to be received by June 30th. We are really aiming to file all of our cases as soon as possible, but definitely within April and May, unless there's a strategic reason to file later. So for example, if you are traveling, and we'll talk about travel later, but if you or your employee is submitting an H-1B Cap subject petition and you plan to travel this summer, have a conversation with your immigration lawyer to make sure that you have a clear plan for that. If you travel, again, we'll talk about this in more detail in a minute, but if you travel while the H-1B petition is pending, and if you have requested a change of status from something like F1 or H4 or anything, from a different visa classification to H-1B, then the petition itself will be denied. The petition will not be denied. The change of status request will be denied. So again, it will not affect the petition itself, but the change of status will be denied. So that could be a reason to wait, but we don't want to wait until the last minute to file these. Second question, what documents are required? So in general, the documents that are required from the employer include things like the FEIN assignment letter, maybe some corporate documentation just to make sure that we have the correct corporate name and the correct corporate information on the petition. It's really important in general, but especially in this administration, that everything be accurate and consistent from the get-go. And then information from the employer about what is the job title of this position that's being offered, the job duties, the job description, the requirements for the position, the worksite location, the salary. All of this information, the documents and the information, we walk clients through step by step to get it. So you don't have to worry about, if you are a client of Sumner Immigration, you do not have to worry about, oh my goodness, what do I need to submit? When do I need to submit it? We will tell you exactly what to do, when to submit it, what we need, and we'll let you know if we have questions about it or if we think we need additional documentation. The documentation from the employee that we will need includes things like, of course, your passport, your I-94 if you're currently here in the United States, your visa, educational documents, copies of your degrees and transcripts. We may ask for a copy of your resume, though we likely will not include that with the filing. And then documentation of your current status if you're in the United States right now. It is possible to file an H-1B petition for someone who's currently outside of the United States, in which case we don't need your immigration status documentation unless you've been here before, perhaps. But if you're here now, we want to make sure we have the documentation to show that you are in valid status in the United States. And again, we'll ask you for that specific documentation if you're our client, so you know exactly what to submit and what we need. The third question, should I submit the H-1B petition in premium processing? The answer to that is it depends, / maybe, / it's up to you. And I know that's not helpful, but here are some things that you can consider for the question of whether to file in premium processing. Reasons that you might want to file in premium processing include just knowing. Sometimes the employer and or the employee just want to know that the petition is approved and have it done. They can enjoy the summer without having to worry about it, and they know that it's approved and that the H-1B status will take effect on October 1st. That's the first date that the H-1B status can take effect. So if that's worth it to you, absolutely fine. As far as processing times, if you don't do premium processing, it's all over the place, right? It can be, there are going to be some petitions, and it happens to us every year, some petitions that we submit in April that are approved in May or June or even April, and then other petitions that we also submit in April that are approved much later in the summer or potentially even into the fall. So it really varies. In general, the processing time, and I hesitate to even say this, but in general, the processing time is 4 to 5 months, but that really varies and is not a guarantee at all. So one reason to file in premium processing, again, is if you just want to know and if it's worth it to you to spend that money. The other reason, a potential other reason to apply in premium processing is if you have travel plans. And I know we talked about travel briefly just a minute ago, but as I said, if you have travel plans, if you, the beneficiary, have travel plans over the summer, or really any time between the time that we file the H-1B petition and the time it's approved, or really between the time we file in October 1st, talk to your immigration lawyer to come up with a plan. It's not that you can't travel, it's that we want to make sure that it's done correctly and strategically and done with intention. So talk to us if you plan to travel. If something comes up after we have filed, talk to us so that we can make sure you're aware of what you can and can't do in terms of travel and what the implications would be. Like I said, if we have filed an H-1B petition requesting a change of status, if you leave the United States while the petition is in process with USCIS before it's approved, then the change of status portion of that request will be deemed abandoned and denied. That does not affect the underlying petition. Assuming it's otherwise approvable, then it could still be approved or should still be approved, but the change of status request would not be approved. So again, it's not that you can't travel, but talk to us. So every year there are clients who have travel plans, and for certain clients, we advise them to file or give them the choice to file in premium processing so they know they have the petition approved and then can go travel and come back. Again, make sure that you talk to your immigration attorney about that because it's fact specific, but that can be a reason to use premium processing. A reason not to use premium processing is the cost. The cost is $2,805, and sometimes you just don't want to pay that if there's not a reason to pay it. The other reason, or a potential reason to not use premium processing, it could potentially increase the chances of a request for evidence. This is a rather widely debated topic amongst immigration lawyers and others in the immigration law field. And there's absolutely nothing official, nothing written that says, if you file in premium processing, then yes, you absolutely will get a request for evidence. A request for evidence is when USCIS requests additional information regarding that particular petition. It doesn't mean necessarily that they're going to deny the case. It doesn't mean that they're going to approve the case. Some people have said, oh, I got a request for evidence. That's good. It means they're going to approve it, right? No, it means they have a question about the case or that they're buying time. So there are a couple of reasons that they can issue a request for evidence. One, because they really do have questions. They really do feel like they need additional documentation relating to the case. Or it is possible, there is a theory out there, and remember, immigration officers are human, that if you file in premium processing, you may receive a request for evidence, especially towards the end of that premium processing timeframe. And it's not so much that really USCIS needs or wants additional information. It's because they're buying time, because they haven't had time to go through the petition and actually make a decision yet. And so they're buying time. That does not mean that if you, I want to be clear about this, that does not mean that if you file in premium processing that you absolutely will get a request for evidence. I would say, I was going to say every day, but that's an overstatement. But every month we have petitions approved through premium that we file through premium processing that do not receive requests for evidence. So it's not black and white. In addition, just because you do not file through premium processing, if you file in regular processing, that does not mean that you will not receive a request for evidence. So keep in mind that there's this theory out there that can be somewhat true. We have seen this happen in our practice and in my practice over the past 19 and a half years, that it can be more likely that you would receive a request for evidence, but it's not a guarantee. I would not let that I would consider that, but I would not let that be the deciding factor in whether to file in premium processing or not, because it's not anything official. And talk to your immigration attorney, because we can identify strengths and weaknesses of the case and say, well, we can't make any guarantees, of course, but we can give you some thoughts as to what a request for evidence might be about. Another reason not to file in premium processing is because you will not have H-1B status any sooner than if you file it necessarily, if you file in the regular processing. By that, I mean the H-1B status cannot become effective until October 1st of 2025, period. So if you file in regular processing, premium processing, whatever it is, and your H-1B petition is approved, let's say, for example, on July 1st, that's great, congratulations. But it does not mean that you hold H-1B status. You cannot hold H-1B status until October 1st. That's when it becomes effective per the regulations. So there's not a benefit there. If you have if you're overseas, or if you have an underlying non-immigrant status that allows you to do the things you want to do, for example, to work, let's say that you have H-4 EAD, then there may not be a valid reason to use premium processing. By the way, with premium processing, you can, like I said, the fee is $2,805, and the government will make a decision on the case within 15 business days, not calendar days, but business days, or issue a request for evidence. If they issue a request for evidence, we usually have 87 days to respond to the request for evidence. And then once we submit the packet with the request for evidence documentation, the response, USCIS then has another 15 business days to make a decision on the case. So that's how premium processing works. So moving on to the next question, how likely is my H-1B petition to be approved? What are the chances of approval? What are the chances of a request for evidence? What are the reasons that a case might receive a request for evidence? That is a big question, and it's a good question. We actually had an employer ask us that yesterday, and it's a great question. He was saying, that's great, we're through the H-1B lottery. Does this mean it's easy from now on? And he didn't use those words, but the answer is no. We have a lot of strategy and intentional preparation in front of us. Again, it's not anything that's overwhelming or needs to be overwhelming or is going to take a tremendous amount of time on behalf of the employer or employee, but we need some information. So the answer to that question, what are the chances of approval? What are the chances of a request for evidence? Why would they deny? Why would they issue a request for evidence? Is, again, it depends. It really depends on the specific case. So in terms of the chances of a request for evidence or approval, even for a specific case where I'm preparing the case, I really can't, I can't control the government. So I can't, very accurately give you a percentage that, oh, I think this case has a 75.2% chance of approval. It doesn't work that way. What we can do is carefully and strategically prepare the case, proactively warn the clients, the employee and employer, of potential issues that we see and give them options. Make sure that they're educated about what we identify as the potential options and or potential issues, and then give them options as to how to proceed and what the pros and cons of those particular options might be. Issues or challenges, reasons that you might get a request for evidence or potentially denial, but really request for evidence potentially are, and it's wide open, right? There are any number of options out there, but it could be, we see to the extent that we see requests for evidence on H-1Bs, a lot of times it's about specialty occupation. That doesn't mean we receive an RFE on specialty occupation on the majority of cases that we file or every case that we file. That's not what I'm saying. I'm saying when we see a request for evidence for an H-1B, a lot of times, not always, but a lot of times it's about specialty occupation. By that, I mean USCIS is saying, hey, we don't necessarily know, we don't think, or we need additional documentation to show that this particular position that's being offered requires a minimum of a bachelor's degree in a specific field of study. So that's something that we carefully address right from the moment we begin preparing a case. We want to make sure that it is, in fact, a position that requires a minimum of a bachelor's degree in a specific field of study to enter that particular occupation, and that the beneficiary, the person for whom we're filing the H-1B, actually has that required education. But that can be tricky. It can be a reason for a request for evidence. It's kind of beyond the scope. We can have another video about specialty occupation RFEs. It would take me a while to go through all of that. But basically, there are some occupations that still you can have approved as an H-1B position or an H-1B occupation, but they're more likely to receive a request for evidence. So there's a source that USCIS looks at. They're not married to it. They're not, there's nothing in the regulations that says this is the only source that you can look at to see if a position requires a bachelor's degree in a specific field of study. But that's what they look at. They look at the OOH, the Occupational Outlook Handbook. Get those words mixed up, but the Occupational Outlook Handbook, if you Google it, if you Google Department of Labor OOH, it'll come up. And you can search by job title. Again, it's a big part of the strategy of the case, but it's something that USCIS looks at. So that could be a reason for a request for evidence. Another reason could potentially be a level 1 wage. So when we file the H-1B petitions, we have to file, like I said, a labor condition application or LCA that attests the employer is going to pay the beneficiary a certain amount. That amount is set by wage data that's provided by the Department of Labor. And there are 4 different wage levels for each occupation. In the first Trump administration, and I believe after that as well, but anyway, in the past, we have had requests for evidence on wage level 1 positions, meaning USCIS had said, hey, you're paying this doctor, for example, a wage level 1. And so we think that that's not an H-1B position. It's not a specialty occupation position because it's a wage level 1. We have, there's no guarantee on outcomes. Of course, we have successfully addressed those before. We're, knock on wood, not seeing those right now, but it is possible that that would come up. And then another reason for requests for evidence is a person's status, their immigration status. If you're requesting a change of status from another visa classification like J or like any H4, E2, any number of other classifications, we have to show that you're maintaining valid status in the United States. That's not true if you're requesting consular processing. If you're saying, all right, I'm going to go get my visa stamped at a US consulate overseas and then come back to make my H-1B status valid. But if you are in the United States and requesting a change of status, we do have to show that you're maintaining valid status now. Usually it's not a big thing. We submit, if you're currently on H4, we submit the relevant documentation. If you're on J1 or J2, we submit the documentation. It can be a little trickier. USCIS can ask for additional documentation potentially in any situation, but especially if a person is on F1 student status and they are currently on CPT, curricular practical training, or they have held CPT previously, or if there's some other question about the validity of their status previously. So that's something that we take a look at and proactively address as much as we can, but that can be a reason for a request for evidence. So moving on to the next question, what if my OPT ends, or what if my employee's OPT ends before October 1st? That is okay. So in general, so if an employee's, let's say you have an employee whose OPT ends, I'm just making this up, on July 15th of 2025, there is something called the H-1B Cap provision that is outlined in the H-1B regulations that says that as long as you meet certain requirements, that person's current OPT, stands for occupational practical training. And basically it's a work permit that is for a national student has for a year after they graduate, they meet certain requirements. And then if you meet certain other requirements, you can have a STEM OPT for an additional 2 years. Anyway, if your OPT is going to expire between, let's say now and October 1st, you can take advantage of Cap Gap, like I said, if you meet certain requirements. So those requirements are that you have to timely file the H-1B petition. So before, during that window between April 1st and June 30th, you have to request a change of status, and the petition, what am I trying to say? Oh, the petition has to be filed before the OPT expires. So, if your OPT expires July 15th, then of course you have to file before June 30th. You have to request, like I said, a change of status. And if the H-1B petition is denied, the Cap Gap benefit goes away. But if it's approved or if it's still pending, then the person's authorization to work, the employment authorization document, is extended. You do have to get the I-20 annotated. That's the document that you get from the school. The DSO at the school will help you with that. But you can extend the H-1B beyond, or sorry, you can extend the authorization, the employment authorization document, basically the work permit gets extended automatically until, and this is a big change, until April 1st of the next year. And I want to make sure I'm telling you the right date because it's new. It just changed recently, and I want to make sure that I'm getting that correct. But know that it is extended until April 1st of the following year. So that is excellent information. An excellent change. It used to be that it was only extended until September 30th, but we have a lot more time now. It's extended until September 30th. Sorry, not September 30th. It's extended now until April 1st of the following year, which is huge. That means that a lot of people who otherwise maybe would have needed to file upgrade to premium processing because their Cap Gap was going to end have a lot more time now. You have until April 1st of the following year. So we're almost done here. The next question, what if I don't have a lawyer yet? Sometimes employers will register for the H-1B lottery themselves, totally fine, and they need a lawyer to help them submit the H-1B petition. We are happy to help with that. It is not too late. If you do not have a lawyer yet, this is a great time to start that process, and we can pick up the process now. We need the selection notice, and then that's basically what we need. And then we would get the other information that we otherwise would get from existing clients. So we're happy to help if you do not yet have a lawyer. Our last question is, when do I have to obtain the H-1B visa? So this is something that sometimes people find confusing, understandably. If you have requested a change of status from another visa classification like L or E or any number of TN, whatever it is, the H-1B1, whatever it is, if you're in the United States in valid status, and again, talk to your immigration lawyer about this, but if you are changing status, if you request a change of status from that visa classification to H-1B, and your H-1B status becomes effective October 1st, you don't have to obtain an H-1B visa in your passport until and unless you leave the United States and then come back in H-1B status. So I literally have had clients who were here, let's say on F1, and they hold H-1B status, they apply for the green card, they never travel outside of the United States, and so they never have an H-1B visa in their passport. If you do travel, then there are certain exceptions, but almost certainly you will need a valid visa in your passport. But you don't have, there's not a big rush to leave the United States and get that visa stamped. It's just next time you travel, talk to your immigration attorney, of course, before you travel, and come up with a plan to get that stamping done. But you don't have to have it done immediately. If you request a change of status, you can remain in the United States, remain working. Your H-1B status becomes effective October 1st, and then you're good to go. So I hope that you have found this information helpful, these FAQs on H-1B Cap filings. If you found it helpful, I hope you will share this video with a friend or colleague. Make sure that you subscribe to our channel, whichever channel you're watching this on, LinkedIn, YouTube, or Facebook, and make sure that you turn on notifications so you don't miss our next video. As I said when we started this video, I'm excited for everybody who was selected. If you were not selected, take a deep breath and join us for the webinar tomorrow at noon. At least register for it so that you will get the recording in your email inbox and you can watch it. Let us know what questions you have. Let us know if we can help. Until next Tuesday, we'll be live again next Tuesday at noon Eastern. Until then, my name is Emily Sumner with Sumner Immigration Law. We help clients around the world and around the United States with family-based and employment-based immigration matters. Until then.